Can I see that? I need him to, he forgot to put his initials on it.
Oh, okay. Go ahead.
Okay. Sorry.
You glazed it? Okay.
Yeah. No, he just signed it.
Okay. That's okay.
Here you go. I mean, you just made it outside. I could buy you a house for it.
The lady who did your secret got the tip from my envelope.
I still haven't gotten the TV route.
Okay.
This morning in my regular division, and of course, Jan Esther flew in to save the day, so we appreciate her more than she knows. Okay, so let's do our to-do list. All jurors are here and accounted for. Defense, would you like to be heard first on the issue that the state raised yesterday about your expert testifying on, and they provided the cases of State versus Nieto as well as State versus Mizell. Yes.
Okay. I think it would be proper for the prosecution to make the initial argument since it's their motion and for me to respond. But if you want me to go first, I can
They
go
made
first.
their argument last night, I heard it.
Okay. First of all, let me differentiate the third district case that they're relying on. That is a duress case where there's no testimony from the purported defendant with regards to being under duress. My client gave a videotaped statement to law enforcement stating that he was the victim of abuse. He posted that the fact that he was the victim of abuse on the social media site where he published the photograph. In addition, he indicated to multiple law enforcement members that he's the victim of abuse. There's a distinct differentiation between what happened in that case and what happened in this case. In this case, my client has audibly told, and it's already introduced into evidence, that he's the victim of abuse, that he is a battered spouse. And that in and of itself should differentiate the two situations. In addition, duress is a common defense that most people that a common person would understand and have general knowledge and information on without needing to potentially hear from a defendant. And if the defendant had made no previous statements that he was acting under duress, I could understand the court's ruling in that situation. In this case, my client gave a videotaped statement to law enforcement where he outlined that he was the victim of abuse. It's clearly differentiated. It's not applicable in this case, and we should be allowed to move forward without forcing my client to take the stand when he's already elicited the appropriate statements to satisfy the distinction, which I don't think even applies because it's a duress defense, which is a nationally recognized commonplace defense versus a very unique defense.
Well, let's talk about Nieto, where they talk about PTSD being akin to battered spouse syndrome.
Well, you're not bound by that district judge. First of all, it's not a
Persuasive.
Well, it's persuasive, but you're not bound by it. And post-traumatic stress disorder, I guarantee you, if I would have told the members of the jury who here's heard of PTSD, everybody would have raised their hand. When I asked this specific jury in this specific instance if they knew what battered spousal syndrome was, Judge, I would say less than 10%, and I would say the majority of the jurors that we have before us had no idea what it was. But more importantly, Judge, here's the issue. He's laid the foundation in the statement that he provided, okay? He has established a prima facie case of duress, which is what you need to do. You need to be able to establish a prima facie case for duress. That's what the case law states. He's done that in his own statement to law enforcement, which the prosecution has entered into evidence.
State, would you like to be heard?
Yes, Judge. Judge, first of all, if there's nothing contradictory, it is controlling, as opposed to just a recommendation as defense would suggest. Second of all, Judge, I would beg to differ regarding the actual legal definition of duress. Much like if you said to jurors, do you know if somebody's crazy? Sure. Well, crazy doesn't mean insanity either. So we all know that these definitions have legal definitions. And while the defendant may have spoken about abuse, much like the Colombian man could talk about how he felt forced, okay, the standard and the definition for duress is what was at issue. That's why you called an expert to explain the psychological symptoms of duress. The standard and what needs to be explained here is battered spouse syndrome. Not that he was hit, but battered spouse syndrome, because that's what they filed under, Judge, within self-defense. That is its own affirmative defense. That's like saying, Judge, that let's have somebody come up and talk about depression even though I filed an insanity defense. You don't get to backdoor it like that. They filed a defense of a syndrome. Well, a syndrome has to be explained properly. And Judge, the point is that the defendant's statement does not lay the predicate like that, which means it's exactly like the cases that the state cited.
What statute is it under, defense?
You're looking for, Judge?
The battered spouse, Judge?
Yes.
I'm going to tell you right now. In the 2013 book, it is...
I'm a little bit more up to date. I'm looking at 2014, but...
Except it was a 2013 crime, Judge, which is why I'm looking at the 2013
Okay, that's fine.
book.
But I'm sure the language wasn't
Yeah, I
altered.
want to find it exactly for
Sorry,
you.
I have it on my phone, but it's...
Well, it's Rule 3.201. That tells them that they have to give us notice. The justifiable use of force, Judge, is Chapter 776.
But I believe there's a specific... Hold on, Judge.
I'm finding it for you, Judge. I want to find you the exact... 3.201, Judge, Rule
I'm sorry, can you repeat?
3.201.
And 3.202. My phone is not working here.
Right. The rule does not say spousal abuse. It says battered spouse syndrome, and that's the rule that they cited in their motion. Well, a syndrome is different from being hit by your wife, as is depression is different from being insane at the time you commit an offense.
I have I
Here.
didn't have my...
Well, let me tell you the context in which I'm looking at this. I reviewed Mr. Medina's statement multiple times last night. He recounts what occurred on the day of the incident, and then he makes one statement at the end of his statement where he goes, I have been dealing with this for 4 years, with no elucidation of what this is. So defense, with that being said, and that being the evidence that you are claiming is enough to get in testimony related to battered spouse syndrome, what is your counter to the state?
Judge, hold on. This is the issue, Judge. In addition to the statement that you've got to understand, the sworn statement, as Detective Grossman stated very clearly, was by his direction. The detective was asking pointed questions. My client would ask the question that was in front of him, and then they would move on. Our position is that he had made, during the pre-interview, substantial reference to a judge. He wrote about
But
it.
is that before this jury? At this stage, is that before this jury?
What, Judge, what he wrote, what he's put on the Facebook post is years of abuse.
Can I see the Facebook post?
Absolutely.
I believe it just says, I was abused. And it doesn't really clarify whether it meant that day or in the past, but I'm willing to look at that again.
Judge, in addition to it, we are going to be laying a foundation with regards to spousal abuse from other witnesses prior to putting on Philip Cook.
Okay, well then let's hear that before we even talk
Right.
about Cook, because right now you're on fumes on getting in
Judge,
Cook's
because-
testimony.
Correct. And let's,
Yes.
if I may.
Yes,
Thank you.
please.
Glasses.
Judge, he makes a reference on the Facebook post, I'm not going to stand anymore with the abuse. So that's making a reference that he had been abused. It's by my...
But abused that day or abused over a 4-year period, that is very weak. So you're going to have to present more before I'm going to allow in the doctor.
Judge, and it was never our position to start with Philip Cook in terms of eliciting what is spousal abuse. We are going to lay the appropriate foundation through witnesses before we can do that. And I can proffer that, Judge, if you look at the sworn statements, they're not introduced into evidence, but I can make reference to the sworn statements by my client's father and his aunt. The day of the questioning, Detective Grossman on direct examination said, I questioned them, or law enforcement questioned them with regards to that issue, and they all answered in the negative. That is 100% inappropriate. That's wrong. Their statements were, Derek Ian Medina, when he asked him about that issue, said yes. He was the victim of abuse. He would complain about the abuse. When they asked Valerie Medina, once again, yes, he was the victim of abuse, complaining about abuse, and that's going to be elicited from the defense.
Well, wait one moment. I recall, and I'm going to allow the state, that when Detective Grossman was asked about that, he said they did not witness it, that they were only told by your client about it.
That's correct, Judge.
Well, Judge, give me a second, Judge.
So is there anything additional that the state...
No, Judge, that's what I was just about to say. First of all, Judge, all of the statements that the defendant made to those people are hearsay, so they're inadmissible. There are statements in Valerie Medina's sworn statement to Detective Grossman, the follow-up sworn statement that we took pursuant to the filing of a notice, well, actually, before that even, about that, says that on no occasion did she ever see anything. Detective Grossman spoke to Mr. Medina about it, but Judge, Mr. Medina, Senior, is irrelevant because he was stricken from their spousal notice abuse. So Mr. Medina cannot...
When did that happen?
Judge, on March the... Sorry, let me look at the date. I'm sorry, on June the 1st, 2015, we were provided an amended notice of spousal abuse defense, which I'm not going to refer to it as that because that's improper, of battered spouse syndrome pursuant to the rule that defense cited in their motion. And Derek Ian Medina is no longer on that list, Judge. We didn't take his deposition as we did everybody else's on the previous list because he was stricken. So I would ask this court that if there's going to be any testimony, other than the hearsay that would ordinarily be inadmissible, it shouldn't be allowed because he was removed from their spousal abuse list.
Judge.
So defense.
Well, let me address that issue. With regards to Derek Ian Medina, our recollection, my recollection, and obviously I'll recall Detective Grossman if need be, is he said that when I asked him as to whether or not this was investigated, he said that there was no reason to investigate the spousal abuse. He said that he asked, and I have it written in my notes, that he asked the father, the aunt, and the mother, and they all denied the fact of the issue with regards to whether or not my client was a victim of abuse. That's clearly in contradiction to what's in their sworn statements. And I can proffer to the court. Hold on. I can proffer to the court, Judge. On page 4 of Derek Ian Medina, the father, you said that he complained that she's aggressive. He said that she beats him up a lot, and he doesn't have a right to respond because she gets very aggressive.
Right. He said to me...
Hold on. Respectfully, Judge.
Sorry.
Right.
You're right.
But
Go ahead.
this is to impeach Detective Grossman. His statement was, we asked a question, and there was nothing to follow up on. This is a complete contradiction. This is to impeach Detective Grossman. He said, Judge, I remember asking him, because there was an issue as to whether or not Detective Grossman interviewed him. He goes, no, it was Detective Sanchez. So I go, okay, well, did you review the sworn statement? He goes, yeah, and there's nothing there for me to follow up. He says it in black and white with Valerie Medina. Also, another sworn statement, this one done by Detective Grossman. Hold on. Are you aware of any direct instances with Jennifer where she would strike or hit Derek? Yes. And did you ever witness any of these incidents? No. How were you aware of these incidents? Derek would tell me. Are you aware of the last time Derek told you that he struck her? These are issues that are in direct contradiction to his testimony on the stand.
Respectfully, I'm going to have to disagree with you,
I'll pull
Mr.
the
Zagne.
transcript respectfully, Judge.
You may, but I'm telling you right now, he was asked. They did not witness it. obviously I don't have a transcript in front of me, but I also reviewed my notes last night, and yes, he said he did not investigate it, but he said they did not witness it. So, first of all, it's hearsay,
Right.
Hold on,
and
Judge.
second of all, that's not what my recollection of what the detective said.
Judge, we have what had been provided to us by the prosecution. It appears to be Officer Detective Venturulli, one of the South Miami officers. His testimony was that after he heard the initial statement from my client, that when he went into the holding cell, that they were there for several hours, he didn't say anything to him. The video here shows, if I can play it, Judge?
Video of what?
Why is this relevant to what we're discussing now?
Because
I'm
it's
sorry. With all due
because it
respect.
has to do with my client's issue as to whether or not he's raised being a victim of battered spouse. Judge, it's...
But that detective indicated
No.
that nothing was said.
Correct. And we have video that the
So then you can present that
provided.
evidence, but,
Well, we're going to, but...
okay, so then what are
When
we
I
arguing about?
When I recall, well, the evidence shows my client, I was going to do this to impeach him. I didn't plan on having to use this for today's hearing because I thought my client's statement in and of itself formed a prima facie case, Judge.
It looks like we're somewhat arguing in the hypothetical here, so let's get back on track. Who is the defense's next witness?
Mr. Coleman. We're recalling Mr. Coleman, Judge. We provided the prosecution with the actual edited version of, not edited, slowed down, frame by frame, of what the prosecution provided to us in discovery from 7:33 and 20 seconds to 7:33 and 40 seconds. In the highlighted area, when I paused for the court to view yesterday, which shows a black object, which coincides with the same size and shape of the knife handle, that you see it budding out in the video a second or two before the shooting.
When did you provide this
This
to the
morning.
state?
27 minutes ago.
Judge, Mr. Coleman prepared this for us. He was driving
my
to St.
problem.
Petersburg.
But let me ask you this, defense.
This is
Was the
27.
first time you've ever provided the state with the slowed down version of this video this morning, 27 minutes ago?
With the video that they provided us,
I'm asking you
Correct,
a
Judge.
pointed question. I'm
Yes,
not
Judge.
asking for explanation.
No, yes.
The slowed down version of, don't talk over me. The slowed down version of the DVD that you provided to the state this morning, 27 minutes ago, is that the first time the state has been provided that item?
Judge, last night we
I'm
contacted...
asking you yes or no.
Yes, if I may explain. We spoke about this yesterday. We indicated that we would do one of two things. We would either have Mr. Coleman come back today and produce what we believed that he had previously produced, or we would try to bring this in through our crime scene reconstructionist and get you guys a copy because we believed that we were going to be calling him as a witness. So we found out the health issue that he's having is serious. We may not be able to call him as a witness at all. Okay? So we went with the only option that we have left, which is to provide Mr. Coleman, who simply... Judge, I believe that what the prosecution gave us at the inception of this case was a frame-by-frame analysis of what's in the DVR. So in essence, what that means is the prosecution, by having a still frame with their crime scene, their Homeland Security Bureau, whoever actually reviewed the files, has actually had every still of this incident from the inception of this case. So, with all due respect and candor, they've had
But
this.
they have not, State, have you yet had an opportunity to review what is on that disc?
No, I got it 27 minutes ago. I was standing here preparing for you to come in. And if the court recalls last night, I said, when I get it, Judge, I'm going to want to do exactly what I did, even though it is what I gave them. You know why, Judge?
And
because their expert touched
where is your forensics person that you want to run this by?
Detective Ruano.
I apologize, I couldn't recall.
No,
his
I'm
name.
just at...
Yeah, and I don't know who you wanted to run it by, but I know you said yesterday you wanted to run it.
As I told the court last night, I would want to spend time, as we did the day before when we got an exhibit from the defense, it would be Detective Ruano to review it.
And where,
I
how
don't know,
soon can
Judge.
you
I
have
didn't know
contact
when I was getting it.
Probably
Can
back
you
in his
reach
office.
out?
Probably back at his office.
Can you reach out to him and see when he would be available for you today?
I can,
Okay,
sure.
okay.
Well, Judge, it's the defense's position that, I mean, if they want, they can email that to them right now. You can start looking at it, because it's something that can be listen, it's...
Okay, let's take a 2-minute recess. Can you go make that phone call and
Yes.
see when when your expert can